When you want to prove something in court, you will almost surely need witnesses to testify on your behalf. At an initial hearing, like a temporary orders hearing, or a hearing on a motion for order to show cause, if there are issues that need to be proven by other witnesses, these witnesses usually are not called into court to testify, but their testimony is preserved in the written form of a sworn affidavit or verified declaration of your witness's testimony to the court. Witness affidavits and declarations can help you prove why the court should rule in your favor. The witness testimony is proffered, meaning that your witness does not have to actually testify, and instead the testimony is proffered in the form of the affidavit or declaration of that witness. It used to be that even though the witness whose testimony was preserved in the form of an affidavit or declaration had to be physically present. This recently has largely been done away with. Again, however, if you have a witness who is willing to come to court, it's always good for the court to connect a name and a face with the affidavit or declaration. And if the court has a question for this witness that wasn't covered in the affidavit, by having that witness present in the court, he or she can answer the follow-up questions that the court may have. The court does not only consider witness testimony, but will also review any records or other documentation which is relevant to the issues to be decided. It is extremely important to take the time before the temporary hearing to get the needed documentation in a form that is admissible in evidence. Your attorney can help you understand what you need and review the documents as you collect them. It is your responsibility to collect this documentation, and once you know what kind of evidence is needed, you can do that. We are all afraid of things we don't understand. To help yourself, you will want to review any documents you will refer to during your testimony. Also, review any statements you made and talk to friends, family, or coworkers to recall details you may have forgotten. A visit to the courtroom before your case may make you more comfortable about your court appearance. After you watch a few cases, you will see that no one dies or is seriously injured when testifying. You will feel better when it is your turn. Always check with your attorney's office a couple of days before your hearing or trial to make sure your case will go on as scheduled. Often cases are continued or postponed by the court for one reason or another, and we do not want you to waste a trip if it is avoidable. Of course, your attorney will do his or her best to notify you of any continuances. Watch your speech and phrasing. Do not guess what you don't know or guess the answer to a question. Don't respond with, "I think," or "I believe," or "it must have been this way," if you don't actually know what happened. The judge does not care about your speculations. The judge wants to know the facts. So, if you estimate a time or a cost, make sure the court knows it is an estimate. If you make a mistake during your testimony, correct it as soon as possible. Tell the truth. The truth is going to come out eventually anyway, and it is better coming from you than from the other side. If the other side catches you in a lie, you may lose your case. However, make sure you told the truth to your attorney before you tell it in court. One of the oldest tricks in a lawyer's book when questioning you is to ask you if you have discussed the case with your attorney or other witnesses. If the other side asks you this, tell the truth. You have. The other side is not asking you if you have fabricated a story, but only is asking you if you have talked about your testimony in advance. Only a fool would go to court without having discussed the case with his or her attorney and his or her witnesses. So, if you are asked whether your attorney helped you prepare in advance of being questioned, don't be afraid to answer honestly with yes. Sometimes the opposing lawyer will follow up by asking if your attorney told you what to say in response to particular questions. Your attorney is permitted to tell you what kinds of questions you may expect to be asked, but cannot tell you how to answer those questions. Assuming that your attorney is a good and ethical attorney, if you are asked whether your attorney told you how to answer, you can confidently respond with no. The judge will eventually sign the decree of divorce ending your marriage. After the divorce, you and your ex-spouse will have 2 separate households. You will have to maintain those 2 homes on the money with which you maintained 1 household earlier. Furthermore, if you think that the relationship with your spouse has been a bad one, it usually only gets worse, especially while going through the divorce. Once you are divorced, at least the contact you have with your ex is minimized. After the divorce, you'll be separated, but connected by visitation, child support, alimony, or debt payments, and you'll still have to deal with these problems together. Life goes on after divorce, and we wish you the best in the next phase of your life. Odds are high that you will marry again. Samuel Johnson described remarriage as the triumph of hope over experience. If you marry again, you may want a prenuptial agreement. This is also called a premarital or antenuptial agreement. They are often a good idea if you are remarrying. A prenuptial agreement is an agreement with your new spouse to be made before the marriage. Like health insurance, car insurance, or property insurance, it protects you in the event of a calamity. It's an agreement made by a couple before they marry concerning the ownership of their respective assets, and can cover whether there will be alimony in the event of divorce and other issues should the marriage fail. If you are curious about a prenuptial agreement, it would be a good idea to consider one before you marry again.